Applying to become bankrupt. If you're struggling to make ends meet and you can't afford to pay your debts, then you can apply to make yourself bankrupt. You should seriously consider all the other options before you apply for bankruptcy. Your application will be looked at by someone who works for the insolvency service called an adjudicator. They'll decide if you should be made bankrupt. How to apply. You apply for bankruptcy online. There's a fee of £680 that everyone who wants to make themselves bankrupt must pay before applying for bankruptcy. If you and your partner both want to go bankrupt, then the fee is £1,360. You can pay this fee in instalments. However, your bankruptcy application won't be processed until you have paid the fee in full. What happens when you go bankrupt? If the adjudicator makes you bankrupt, you'll receive a copy of the bankruptcy order and may be interviewed about your situation. Your assets can be used to pay your debts. You'll have to follow the bankruptcy restrictions. Your personal details will be published in the Individual Insolvency Register and in the Gazette, which is the government's publication for public notices. You can apply to have your address removed from the Individual Insolvency Register if publishing it will put you at risk of violence. This will not affect your bankruptcy. After you apply, you'll usually get an email or letter from the adjudicator within 28 days of submitting your application to say if you've been made bankrupt. This can take longer if the adjudicator needs to ask more questions about your application. They'll then issue a bankruptcy order. After you get your bankruptcy order, you'll get a letter from the official receiver within 2 weeks of getting your bankruptcy order. The official receiver is an officer of the court who manages your bankruptcy. You'll also get an information pack that explains what you need to know and what you must do. You might be asked to fill in a questionnaire, attend an interview with the official receiver, give the official receiver more information about your debts, creditors, assets, and income. If you're asked to attend an interview, the interview can be in person or over the phone. The official receiver will check the information they have about your debts and assets, ask for more details, for example about your pension or savings, ask how and why you became bankrupt, answer any questions you have about the bankruptcy process. Restrictions. You have to follow bankruptcy restrictions when you're bankrupt. This means you cannot borrow more than £500 without telling the lender you're bankrupt, act as a director of a company, or create, manage or promote a company without the court's permission, manage a business with a different name without telling business associates that you're bankrupt. It's a criminal offence to break the restrictions. You might be prosecuted if you do. You must cooperate with the people managing your bankruptcy, for example by providing them with the information they ask for. When the restrictions can be extended. Bankruptcy restrictions can be extended if you don't carry out your duties under the bankruptcy proceedings, or if you're found to have acted carelessly or dishonestly. The official receiver will tell you if the restrictions will be extended. You'll be asked to agree to a bankruptcy restrictions undertaking to extend the restrictions. If you don't agree, they'll ask the court to issue a bankruptcy restrictions order. Your assets. Your assets might be sold to pay your bankruptcy debts. You have to hand over your assets to the person appointed to manage your bankruptcy, your trustee. They can be an official receiver, an officer of the court, an insolvency practitioner, an authorised debt specialist. The official receiver will usually act as your trustee to begin with. Assets you can keep. You can usually keep items needed for your job, such as tools or a vehicle. Household items, such as clothing, bedding or furniture. You might have to give these items up if they're worth more than a reasonable replacement. Your bank accounts. You must give the official receiver your bank cards, checkbooks and credit cards for any accounts you're no longer allowed to use. This includes any account that was overdrawn on the date you were made bankrupt. Your accounts will be frozen, but your trustee may release money you need urgently, for example to buy food. Your partner's share of any money in a joint account. Your bank will also decide whether you can continue using your accounts. Your pension. You usually keep any money you've paid into a pension. If you're getting pension payments when you're made bankrupt, those payments usually count as income. Speak to your trustee or read the guidance to find out how bankruptcy will affect your pension. Your home. Your home might be sold depending on your equity. Your share after any secured debts, like a mortgage, have been paid. You might have to give up your equity, legal ownership of the property if your equity is £1,000 or more. If your trustee has not put your home up for sale within 3 years, it will be transferred back to you. Sole owners. The equity and legal ownership are transferred to your trustee. This means you cannot sell the property or claim any money from a sale. A bankruptcy restriction or notice is added to your property's entry in the land register to say this. It can't be removed unless it was put on in error. Joint owners. The equity is transferred to your trustee. A Form J restriction is added to your property's entry in the land register. This means your trustee will be told of any dealings connected with your home. For example, if you tried to sell it. It can be removed if you can prove that you, as the bankrupt, do not have a share in the property. For example, if your partner owns the property. The owner has to send HM Land Registry a signed statement saying they are not the bankrupt person and an application for the cancellation of a Form J restriction. Stop the sale of your home. You can get legal advice to find out if you're able to stop the sale of your home if, for example, the value of your equity is less than £1,000. The equity or legal title can be sold to someone else, such as a partner. The sale can be delayed for up to a year if you need to organise somewhere for children or a partner to live. You can get advice from civil legal advice to see if you're eligible for legal aid, which will help you with your legal costs. Rented property. Your landlord may be told that you're bankrupt and your rental situation may be affected. In some circumstances, you may be asked to move to a cheaper rental property. Your income. If you have spare monthly income, your trustee may put an income payments agreement, IPA, in place. This can last up to 3 years. If you're getting pension payments when you're made bankrupt, those payments usually count as income. If you don't agree to the IPA, your trustee can ask the court to order you to make monthly payments. This is called an income payments order, IPO. Your official receiver will set up your IPA or IPO and charge a fee. The fee can be up to £150 and is taken out of your first payment. If your income comes entirely from benefits, then the trustee will not seek an IPA. The monthly amount you pay depends on how much you can afford after essential expenses like food and bills are paid. When bankruptcy ends. Your bankruptcy and the restrictions usually end automatically 12 months after the adjudicator made you bankrupt. In some circumstances it can be longer, if, for example, you don't cooperate with your trustee. Assets that were part of your estate during the bankruptcy period can still be used to pay your debts. Check your discharge date online using the Individual Insolvency Register. Bankruptcy registers. The Individual Insolvency Register is updated within 3 months of your discharge. You must apply to both Land Charges and HM Land Registry to have your bankruptcy entry removed from any properties you still own after paying your debts. Your credit record. Credit reference agencies will not be told directly when your bankruptcy ends. They'll get this information from public records. Your bankruptcy can stay on your credit file for 6 years from the date of your bankruptcy. Once your bankruptcy has ended, apply for a copy of your credit reference report and contact the credit reference agency if it needs updating. Debts that will not be written off. When you're discharged, you'll be released from most, but not all of the debts you owed at the date of bankruptcy. Debts you will not be released from include debts arising from fraud, anything you owe under family proceedings unless the court decides otherwise, damages for personal injuries to anyone unless the court decides otherwise, debts which were not included in the bankruptcy itself,